General provisions.
Section 224. Bonds, what officers to give liability on. The General Assembly shall provide by a general law what officers shall execute bond for the faithful discharge of their duties and fix the liability therein. The previous Constitution contains a similar provision. Early in the history of the Commonwealth, even before it was a constitutional obligation, the General Assembly enacted statutes that required certain officers to execute bonds that guaranteed faithful performance of their official duties. Pursuant to Section 224, the General Assembly has enacted similar statutes. In the opinion of the Attorney General, Section 224 does not require auxiliary police, who form a part of a county or city civil defense organization, to furnish any type of bond.
Section 225. Armed men not to be brought into state, exception. No armed person or bodies of men shall be brought into this state for the preservation of the peace or the suppression of domestic violence, except upon the application of the General Assembly, or of the Governor when the General Assembly may not be in session. The framers of the current Constitution inserted this provision because of their fear of what an armed body of troops could do to civil authority and individual liberties if brought into the Commonwealth to put down some act of domestic unrest. Supporters of Section 225 noted that in other states armed men had been brought in to put down violence and, although no specific example was cited, doubtless the use of Pinkerton detectives and special deputies to break up labor strikes was on the mind of at least some of those who supported this provision. Further, they might have been thinking of the temptation some individuals might feel to call in out-of-state private armies to quash the feuds that had so afflicted the eastern part of Kentucky. The General Assembly, pursuant to Section 225, has enacted a statute that makes it a crime to bring in an armed person or persons into the state to preserve peace or suppress violence without legislative or gubernatorial consent.
Section 226. State lottery, charitable lotteries and charitable gift enterprises, other lotteries and gift enterprises forbidden. 1. The General Assembly may establish a Kentucky state lottery, and may establish a state lottery to be conducted in cooperation with other states. Any lottery so established shall be operated by or on behalf of the Commonwealth of Kentucky. 2. The General Assembly may by general law permit charitable lotteries and charitable gift enterprises, and, if it does so, it shall a. Define what constitutes a charity or charitable organization. B. Define the types of charitable lotteries and charitable gift enterprises which may be engaged in. C. Set standards for the conduct of charitable lotteries and charitable gift enterprises by charitable organizations. D. Provide for means of accounting for the amount of money raised by lotteries and gift enterprises and for assuring its expenditure only for charitable purposes. E. Provide suitable penalties for violation of statutes relating to charitable lotteries and charitable gift enterprises. And F. Pass whatever other general laws the General Assembly deems necessary to assure the proper functioning, honesty, and integrity of charitable lotteries and charitable gift enterprises, and the charitable purposes for which the funds are expended. 3. Except as provided in this section, lotteries and gift enterprises are forbidden, and no privileges shall be granted for such purposes, and none shall be exercised, and no schemes for similar purposes shall be allowed. The General Assembly shall enforce this section by proper penalties. All lottery privileges or charters heretofore granted are revoked. Section 226 originally prohibited lotteries, which once funded schools, libraries, hospitals, churches, and roads in 19th century Kentucky, but by the time of the Constitutional Convention had fallen into disrepute. Critics had come to regard late 19th century lotteries as less interested in raising money for charity and public works and more interested in exploiting people who could least afford to gamble. By the latter part of the 20th century, lotteries had come back into vogue as an easy way to raise money for the revenue-starved state governments. In 1987, a dark horse candidate, Wallace Wilkinson, won the Democratic Party nomination for governor and the governorship itself, in part because of his advocacy of a state lottery. In 1988, at Wilkinson's behest, the General Assembly proposed an amendment to Section 226 that authorized a state lottery, and the voters approved the amendment in the general election of the same year. A few weeks after the voter approval of the amendment, a special session of the General Assembly established a state lottery. Several attempts by the General Assembly to legalize charitable gambling proved unsuccessful because of judicial rulings or opinions of the Attorney General that declared such efforts to be in violation of Section 226, for example, Otto v. Kosofsky, 1971. In 1992, at the urging of the Catholic Church and other charitable organizations that traditionally relied on bingo and similar games to raise money, the General Assembly proposed a further amendment to Section 226 that would authorize it to permit charitable lotteries and gift enterprises. The voters approved this amendment in the general election of 1992, and the General Assembly enacted a charitable gaming statute in 1994. The Attorney General has issued two opinions concerning Section 226 as amended, namely that Section 226 does not permit casino gambling, and that it does permit a lottery game based on horse races in which the odds of winning are 1 in 35 million. Section 226A was repealed in 1935. At the time of its repeal it said, manufacture, sale or transportation of intoxicating liquors prohibited, exception, legislature to enforce.
Section 227. Prosecution and removal of local officers for misfeasance, malfeasance, or neglect. Judges of the county court, justices of the peace, sheriffs, coroners, surveyors, jailers, assessors, county attorneys and constables shall be subject to indictment or prosecution for misfeasance or malfeasance in office, or willful neglect in discharge of official duties, in such mode as may be prescribed by law, and upon conviction his office shall become vacant, but such officer shall have the right to appeal to the Court of Appeals. Provided, also, that the General Assembly may, in addition to the indictment or prosecution above provided, by general law, provide other manner, method or mode for the vacation of office, or the removal from office of any sheriff, jailer, constable or peace officer for neglect of duty, and may provide the method, manner or mode of reinstatement of such officers. Section 227, as originally written, essentially adopted the language of the Third Constitution, which in effect provided for the removal of county officials by successful prosecution for misconduct in office. The framers of the Third Constitution incorporated this remedy because previously, the only way to remove county officials, except for justices of the peace who could be removed by conviction for misbehavior in office, had been by impeachment and legislative trial, a difficult process at best. In 1919 voters approved an amendment to Section 227 that authorized the General Assembly to provide for another method of removing sheriffs, jailers, constables, or peace officers for neglect of duty and another method for reinstating them. The General Assembly proposed the amendment in order to combat lynching, which had been too common a problem since the Civil War. Between 1866 and 1919, Kentucky mobs lynched 344 individuals, over 70% of whom were African Americans. Peace officers who had custody of prisoners who were the objects of lynch mobs often did not resist these mobs and sometimes even aided and abetted their vigilantism. Pursuant to Section 227 as amended, the General Assembly in 1920 enacted a statute that provided for the automatic removal from office of peace officers from whom prisoners were taken and lynched or injured, although the officers could be reinstated if they convinced the governor that they had done all in their power to protect the prisoner. After the statute went into effect, only 8 Kentuckians were lynched, with the last lynching occurring in 1934. The Kentucky Court of Appeals has defined a malfeasance as the intentionally wrongful or grossly negligent performance of an official duty. In Robbins v. Commonwealth, 1929, and neglect of duty as the careless or intentional failure to exercise due diligence in the performance of an official duty, in Holliday v. Fields, 1925. The court also held that a jailer is not guilty of a misfeasance if he allows a prisoner to do unauthorized work, in Lovell v. Commonwealth, 1892, but is guilty of a misfeasance if he keeps a filthy jail that endangers the health of prisoners, in McBride v. Commonwealth, 1868.
Section 228. Oath of Officers and Attorneys. Members of the General Assembly and all officers, before they enter upon the execution of the duties of their respective offices, and all members of the bar, before they enter upon the practice of their profession, shall take the following oath or affirmation. I do solemnly swear or affirm, as the case may be, that I will support the Constitution of the United States and the Constitution of this Commonwealth, and be faithful and true to the Commonwealth of Kentucky so long as I continue a citizen thereof, and that I will faithfully execute, to the best of my ability, the office of, according to law, And I do further solemnly swear or affirm that since the adoption of the present Constitution, I, being a citizen of this state, have not fought a duel with deadly weapons within this state nor out of it, nor have I sent or accepted a challenge to fight a duel with deadly weapons, nor have I acted as second in carrying a challenge, nor aided or assisted any person thus offending, so help me God. The General Assembly established the anti-dueling oath by statute in 1812 as a requirement for officers, legislators, and attorneys. The legislators did this to discourage dueling, a formal way for supposedly honorable men to sometimes settle their differences in occasionally fatal ways. Delegates to the Constitutional Convention of 1849 inserted the oath into the Third Constitution for the same reason, although opponents argued the duel was a better way to settle affairs of honor than the increasingly popular spur-of-the-moment street fight that often put one combatant at a severe disadvantage to the other. The committee that drafted the general provisions of the current Constitution recommended the deletion of the anti-dueling part of the required official oath because the duel had become extinct and the retention of the oath would subject Kentucky to ridicule. A majority of delegates, professing fear that its deletion would cause the duel to revive, voted to retain the oath. This section has produced relatively little appellate litigation. The most famous controversy regarding its anti-dueling provision concerned an unsuccessful effort of the Republican Party to have the Democratic clerk of the Court of Appeals, Thomas C. Jones, declared ineligible because he had allegedly accepted a challenge to a duel. The Court of Appeals ruled that Jones could continue to hold his office because he had not been convicted of accepting a challenge to a duel or of falsely swearing that he had not accepted such a challenge, in Commonwealth v. Jones, 1874. The Court of Appeals ruled that the section as it appeared in the Third Constitution applied to all state, district, county, city, and town officers, in Morgan v. Vance, 1868. The Attorney General has issued an opinion that all public officers must be citizens of Kentucky in order to execute the constitutional oath and hold office in Kentucky. The Special Commission on Constitutional Review of 1987 recommended that Section 228 be amended to remove dueling references from the oath of office.
Section 229. Treason defined, evidence necessary to convict. Treason against the Commonwealth shall consist only in levying war against it, or in adhering to its enemies, giving them aid and comfort. No person shall be convicted of treason except on the testimony of 2 witnesses to the same overt act, or his own confession in open court. Section 229 adopts virtually the same language about treason as found in the previous constitutions, and virtually the same as found in the federal constitution. It has not been the subject of published adjudication. The Special Commission on Constitutional Review of 1987 recommended the repeal of Section 229. Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book, The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.